Hello, hello, hello. Good morning, good morning, good morning. Mm. Well, um, and if the law is the law, why did these two cases, the Mr. Chow case and the Karmelo Anthony case, end so differently? You know, every once in a while, a couple of court cases come along. They force you to admit that the bigger question is whether a person is not whether a person is guilty or innocent. Um, it forces you to ask whether the legal system is actually applying the same rules to everybody in the same fashion. Because I can accept a guilty verdict. I can accept that. I can accept a not guilty verdict. What I have a much harder time accepting is when two cases that seem to revolve around the exact same legal principles produce completely opposite outcomes. And nobody seems interested in talking about why. I want to put these two cases side by side that a lot of people would rather keep separate. One is the case of Rick Chow, the South Carolina store owner who chased and shot a 14-year-old Cyrus Carmack and was acquitted by a jury. The other is the case of Karmelo Anthony, the Texas teenager who stabbed Austin Metcalf during a confrontation at a high school track meet and was convicted of murder. Now, before anybody gets upset about this, let me make something very clear. I'm not saying these cases are factually identical. They are not. One involved a gun and one involved a knife. One defendant was an adult and the other was a teenager. The victims made different decisions that day, and the circumstances surrounding those confrontations were different. I understand that. But I also understand that the legal question in both trials was exactly the same question. Neither jury had to decide who caused the death. Both defendants admitted that they were responsible. The only real question in either court case was whether the use of deadly force was legally justified. In other words, did the defendant reasonably believe that deadly force was immediately necessary to prevent death or serious bodily harm? That is the same legal principle in South Carolina that it is in Texas. That is the same concept every defense case is built upon. It is not about who we like. It's not about who we sympathize with. It's not about which victim we think made worse decisions. It's about whether the threat was immediate, whether the response was necessary, and whether there were other options besides taking a human life. And when I lay these two cases out side by side, I cannot help but ask whether two different juries applied two different standards. Let's start with Rick Chow. According to the evidence presented at trial, Cyrus Carmack Belton and several other friends entered Rick Chow's convenience store. At some point, there was a dispute involving 4 water bottles. The prosecution argued that there really was no theft because of the water bottles because they were returned or they were paid for. The defense argued that Chow reasonably believed the boys had stolen from his store. Now, even if we assume for the sake of argument that a theft occurred, I think we can all agree on one thing. Shoplifting is not a death penalty sentence, right? Nobody in America believes that you should be shot in the back for something that you drink. Hold on. Let me put this
Sure that you know about the two previous shootings before Rick Chow was found not guilty for taking the life of 14-year-old Cyrus Carmack Belton. 2015, a woman stole beer and peanuts. Chow says that she then threatened his life and then she got in a vehicle, so he shot at that vehicle 6 times. Now, thank goodness no one was hurt, but Chow was not charged. Investigators called it self-defense. The second time was in 2018. A man stole oven cleaner. Chow says that that man then assaulted him, so he shot him twice. No charges. Self-defense. The man who stole the oven cleaner, though, he was charged in connection with that case. And then we get to 2023. That's when 14-year-old Cyrus went into a convenience store owned by Rick Chow. Chow said that he stole water. Surveillance video showed that he did not. Cyrus ran from that store, and he ran so hard during the 130-yard chase where Rick Chow was chasing him with a weapon and with his son. Cyrus, this child, ran so fast that he ran out of one of his shoes and his belongings fell out of his pocket, including a weapon, and then he was shot in the back as he was running away. Chow and his son said that Cyrus pointed that weapon at them and that's why Chow fired, but they're the only people who say that. The other witnesses say they never saw anything in Cyrus's hand. And according to the prosecution's experts, Cyrus was shot in the back while he was running away, so how would he have been pointing a weapon that was on the ground that had fallen out of his pocket as he ran for his life? And a lot of people want to say, well, a 14-year-old had a weapon. That's the end of the story. Not guilty for Chow. Having a weapon, no matter what age, does not automatically mean someone gets to take your life. Is it A-okay hunky-dory that a 14-year-old had a weapon? No. But that is not the end of this case. I personally do not believe that he was pointing it at Chow or his son. I believe the witnesses that were there that didn't have a relative on the line for going to prison for this. Other people want to say, well, he may have put the water down, but he planned to steal. Planning to steal or even stealing should not be a death sentence. If he stole a bottled water, which he did not, but even if he did, call the police. Put up a sign that says this kid stole a bottle of water, a basic necessity of life, and he's no longer allowed in this store. If a woman steals beer and peanuts, call the police. Put up a sign that says this woman stole beer and peanuts, she's not allowed in this store. If a man steals oven cleaner, put up a sign, call the police. None of those things should be death sentences. And the fact that people are online saying, well, he intended to steal, well, he had a weapon. You think that means a 14-year-old child should have died?
Now, shoplifting is not a death sentence. It's not a death penalty offense. Nobody in America has the legal right to execute another human being because they think someone stole a few dollars worth of merchandise. That is why the actual case, legal issue in this case, was never really the water bottles. The issue was what happened after those boys left the store. Instead of staying inside, locking the door, calling the police, and letting law enforcement do its job, Rick Chow and his son chose to chase the teenagers. The confrontation moved away from the business and into the neighborhood. The prosecution argued that the pursuit covered more than 100 yards. That detail matters because it goes directly to the issue of necessity. If someone is running away from you, if they're leaving the scene, then you have another option available. You can stop the chase. That was essentially the prosecution's theory. They argued that Rick Chow stopped being a victim of a possible theft and became the aggressor when he chose to pursue the teenagers instead of letting the police handle the situation. They argued that he inserted himself into a dangerous situation that did not have to continue. The defense, however, built a very different narrative. They told the jury that by the time the fatal shot was fired, this case had nothing to do with stolen water. They argued that Cyrus Carmack Belton was carrying a loaded weapon and that during the chase, he pointed that weapon at Rick Chow's son, Andy. The defense argued that in that moment, Rick Chow was not acting to protect property. He was acting to protect his child. Now, if you believe that version of events, then an acquittal makes legal sense. Self-defense law does not require a parent to stand there and hope for the best if they reasonably believe their child is being endangered. The defense only needed to create reasonable doubt. They did not have to prove beyond a shadow of a doubt that Cyrus pointed that gun. They only had to convince the jury that the prosecution had not disproven that possibility. The prosecution challenged that claim. They argued that there was no convincing independent evidence that Cyrus ever aimed the weapon. They argued that having a firearm and threatening someone with a firearm are not the same thing. They also argued that because Chow voluntarily continued the pursuit, he helped to create the circumstances that led to the deadly encounter. Then there is the fact that this has made the case so controversial. Uh, Belton was shot in the back. Legally, I understand that a shot in the back does not automatically defeat a self-defense claim. A person can turn, a person can twist, a chaotic event can produce unusual trajectories. I understand all that, but I also think it's fair to ask whether someone who is moving away from you presents the same level of immediate danger as someone who is advancing towards you. The prosecution clearly believed the threat had ended. They believed that by the time the trigger was pulled, the opportunity to disengage had already arrived. The jury saw it differently, and Rick Chow was acquitted. Now let's move to Texas. The Karmelo Anthony case also started with something that, in a perfect world, should never have become a homicide. The confrontation occurred during a high school track meet. Witnesses testified that Anthony was under a team tent that was not associated with his school and that he was asked to leave. Words were exchanged. Tempers flared. Eventually, Austin Metcalf approached him directly. And according to testimony, there was physical contact, including a shove. The defense built its case around one central idea. They argued that Karmelo Anthony was a small teenager confronted by a much larger individual. Karmelo Anthony was 5'6", 5'7", and Metcalf was 6'2", 6'3". They argued that the entire event unfolded in a matter of seconds and that the law does not require someone to wait until they're unconscious or severely beaten before defending themselves. They reminded the jury that self-defense law is not judged with the benefit of hindsight. The question is not whether Austin Metcalf intended to kill. The question is not whether Austin Metcalf intended to kill Karmelo. The question is whether Anthony reasonably believed that he was in immediate danger. Now, if anyone has been watching my show, this is what I have been saying all along, that the case should hinge on proportionality, and the case should hinge on whether Karmelo Anthony reasonably believed that he was in immediate danger. Okay, so the prosecution, however, argued that the facts did not support that conclusion. They argued that this was a verbal dispute that escalated into a physical dispute, but never reached a point where deadly force was necessary or became legally necessary. They argued that a shove, even an aggressive shove, does not justify introducing a knife into the encounter. They argued that Anthony had opportunities to leave and that instead of walking away, he escalated the confrontation. And ultimately, the jury agreed. They rejected the claim of self-defense and found him guilty of murder. Now, here's the part that I cannot stop thinking about. In the Anthony case, the jury effectively said that the defendant should have done something other than use deadly force. They looked at the evidence and concluded that there were alternatives available. They concluded that the threat did not justify a fatal response. But if that is the principle, then why does it apply to Chow's case? If Karmelo Anthony had a duty to avoid escalating the situation, why didn't Rick Chow? Why didn't Rick Chow have the same duty? If the law expects a teenager to walk away from a confrontation before resorting to deadly force, why didn't it expect the business owner adult, to stay inside his own store and call the police instead of chasing the subject down? That is not a political question. That is not a racial question. That is a legal question. Because when I compare these two cases, I see something that is remarkably similar. In both situations, there was a point where the defendant had another option. Karmelo Anthony had another option, and so did Mr. Chow. In the case of Mr. Chow, the prosecution argued that the alternative was to stop the chase and let law enforcement take over. In the Anthony case, he should have stopped the confrontation and left the tent. In both cases, the defendant chose to continue the encounter. In both cases, both of them introduced or used deadly force. In both cases, they later told jurors that they acted because they were afraid. And that brings me to what I think is the heart of this whole conversation. Fear alone cannot be enough. If fear alone were enough, then every defendant in every homicidal case could simply say, I thought something bad was about to happen. The law has to require more than that. The law requires that the fear be reasonable. It requires that the threat be immediate. It requires that deadly force be necessary and not simply available. That is why prosecutors in both cases focused on the same concepts, which I have said weeks ago, months ago. I said these cases should come down to proportionality and whether they both fear for their lives immediately. I said that. Go back and look at some of the videos that I did. I said this is what this case should come down to. Both cases. Proportionality and reasonably. The prosecution in Texas argued that a shove and an argument did not justify a fatal stabbing. The prosecution in South Carolina argued that a fleeing teenager did not justify a fatal shooting. They were making the same argument. They were arguing that the level of force used exceeded the level of danger actually present. And that is why I think there's a serious argument that these cases should have produced the same result. Now, I understand that some people will hear this and say, no, both should have been acquitted. No, both should have been convicted. That is a logical, consistent position. If you believe that both defendants reasonably feared for their safety and that the state failed to disprove self-defense, then you can make that judgment. But I think there's an equally strong case that both should have been convicted. I say that because in both cases, I see opportunities to disengage both. I see the moments where a fatal outcome was not inevitable. I see situations where one decision changed everything. Rick Chow could have remained inside his business and called the police. Karmelo Anthony could have stepped away from a confrontation that was escalating. In both situations, there were alternatives to deadly force. And that is what troubles me, and it should trouble everyone else. What troubles me is not necessarily that one jury reached one conclusion and another jury reached another one. Different juries see different evidence all the time, and that is the part of the system. What troubles me is that the underlying legal principles seem to have been applied differently. If one jury believes that a defendant should retreat from conflict when there's an opportunity to do so, then why does another jury excuse a defendant who actively pursues the conflict? If one jury says a defendant's fear was not enough to justify deadly homicide, then why is it another jury is willing to accept a very different claim of fear under circumstances where the threat may have already been ending? Those are not easy questions, but they're fair questions. And before anybody misunderstands me, I am not standing here to tell you that either victim was perfect. Austin Metcalf may have made the wrong decision by confronting someone. Cyrus Carmack Belton may have made the wrong decision by carrying a gun. None of us know exactly what was in their minds in those final moments. But our justice system does not ask juries to decide whether the victim was perfect. It asks juries to decide whether the defendant had the legal right to take a human life. That is a much narrower question. And it's supposed to be answered using the same legal standards every single time. Maybe you think Rick Chow was justified because he believed his son was in danger. That's your right. Maybe you think Karmelo Anthony was justified because he believed he was about to be seriously hurt. That is your right too. What I have a harder time understanding is how someone can look at these cases and say one defendant had no obligation to avoid deadly force, while the other did have an obligation to avoid deadly force. Because if the law means anything at all, it has to be consistent. It has to be applied to the same concepts of reasonableness, necessity, proportionality, which is what I've been arguing all along, proportionality, and restraint to everyone who walks into a courtroom. Otherwise, people stop believing that the verdict is about the law and start believing that it depends on the circumstances surrounding the people involved. And maybe this is the bigger conversation that these two cases force us to have. Maybe the legal issue is not whether one jury got it right or the other one got it wrong. Maybe the real issue is whether ordinary Americans can look at these two verdicts side by side and honestly say that the same legal standards were applied in the same way. I don't want to hear the bullshit about Belton having a gun. That has nothing to do with anything. Nothing to do with anything. When you look at the two cases, you keep coming back to the same conclusion. If the standard is the deadly force, and that is supposed to be the last available option, deadly force, then it should have been the last option available for both of them. If the standard is that there must be an immediate and unavoidable threat before someone can lawfully take a life, then that standard should not change depending on the courtroom, the defendant, or the public pressure surrounding the case. Justice does not require that every case end with the same verdict, but it does require that every case be judged by the same rules. And that is why these two verdicts continue to bother some people so much. They're not just debating two tragedies. Most people are out there debating he had a gun, he didn't have a gun, he shouldn't have stabbed him, blah, 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 he wasn't on it. No. You're arguing bullshit. You're arguing bullshit. Both cases came down to proportionality. Both cases should have came down to reasonable danger. Both cases. Okay? They're debating the wrong things. This is not what we should be doing. And this is why these two verdicts are gonna haunt people for a long time. They're not just debating these tragedies, these two separate tragedies, and they came within weeks of each other. They are debating whether the promise carved into every courtroom in America that justice is blind is actually being kept. These are my personal thoughts about these two cases right now, about these two convictions. After laying both of these cases out, after looking at the evidence, after looking at the arguments from both prosecutors and both defense attorneys, I keep coming back to the same thing. I believe Rick Chow should have been convicted too. Now, that does not mean I think Karmelo Anthony should have been acquitted. No, I think Karmelo Anthony should have been convicted as well. Rick Chow should have been convicted as well. Both people should have been convicted because of the proportionality, because of the reasonable threat to their person. Reasonable threat. Rick Chow's should not have had a reasonable threat. He should not have, the circumstances should never have presented themselves. Rick Chow orchestrated those events that led to that young man's death. Rick Chow orchestrated those events. Karmelo Anthony orchestrated those events. Karmelo Anthony should have de-escalated should have left from under the tent. He didn't have to. I get it. Why did he need to pull out a Swiss Army knife? I get it. He should never have pulled out a Swiss Army knife for a fight. Even though he was smaller, even though he felt a threat, he should have left. When an immediate threat is upon you, you need to flee if you can flee. Just like Belton, the young man at the store. He fled the situation. Mr. Chow pursued the situation. Mr. Chow should have been found guilty as well. The same circumstances that Karmelo Anthony presented in his trial should have been the same should have had the same outcome for Mr. Chow. Both legal arguments were presented. Proportionality and reasonable threat. Okay, not to mention that Belton was shot in the back. Okay, fleeing all of this. Okay, so to me, both of them should have been convicted. That's why I say they got the verdict incorrect. Okay, I understand why the jury reached the verdict that they did in the Karmelo Anthony case. I get it. They reached the right conclusion. Okay, they looked at the evidence and decided that a confrontation, even one involving a larger and more aggressive individual, did not rise to the level that justified deadly homicide. They concluded that there were other options available for Karmelo Anthony, and that introducing a knife into the situation went beyond what the law allows. If that is the standard, then I think the exact same principle should have been applied to Mr. Chow. Mr. Chow should have also been convicted. The fact that Belton, the young man who was running away, had a firearm has nothing to do with the case. Has nothing to do with the case. He is fleeing the scene. He is outside. He's no longer a threat. You, as Mr. Chow, pursued the threat. You, as Mr. Chow, pursued the danger. Okay? Having a firearm does not automatically end the conversation. Oh, he had a gun, so yeah, he had a gun. No, has nothing to do with it. The real question is whether he posed an immediate threat at the moment deadly force was used. That is what self-defense law has always been about. It is not enough to say, I was afraid. He had a gun. I saw him have a gun. That don't mean nothing. It means nothing. It's not enough to say he had a weapon. The law asks whether the threat was immediate and whether deadly force was truly necessary. The threat was not immediate. Belton was running away. The threat was receding from you. You were pursuing the threat. The threat was receding from you. Okay? Deadly force was not necessary when he was retreating from you. That's all you had to do was go back into your store and lock the door. Mr. Chow didn't do that. Mr. Chow pursued the threat. Mr. Chow pursued the young man. When I look at the facts that were presented publicly, I see a teenager who had already left the store, who was already not the threat. I see a store owner and his son making the decision to continue the encounter rather than to end the encounter. Okay? I see a pursuit that covered more than 100 yards, 130. More importantly, I see a situation where there was another option available to Rick Chow. Rick Chow could have stayed inside his business. He could have locked the door. Okay? He could have locked the door. He could have called 911. He could have been a witness instead of becoming an active participant. Okay? To me, that matters. I keep hearing that this was not about the water bottles, that this was about a father protecting his son. I understand that argument, but that argument doesn't apply. If a parent truly believes their child is about to be killed, they're going to act. I get that. But the law still has to ask whether the belief was objectively reasonable under the circumstances and whether the defendant helped to create. Mr. Chow helped to create the very danger he later claimed justified deadly homicide. Listen to what I'm saying to you. Mr. Chow helped to create the very danger he later claimed justified this deadly force. And since you helped to bring about the circumstances, create the circumstances in which you had to take someone's life, you're guilty of that. That is the part I cannot get past. If you voluntarily leave a space of safety, you chase someone who is trying to get away and continue a confrontation that could have ended at some point before you even reached that person. It could have ended by you locking the door, click, click, click. Then at some point, you have to take the responsibility for the role you played in creating the tragedy. The responsibility for you accepting the role that you played in a tragedy is that you're guilty. The prosecution in the child case argued that the threat had ended, and it had ended. The young man was running. The threat was receding from you. You pursued the circumstances that made the threat imminent. You brought about those circumstances. Okay. The prosecution argued that the proper response to a suspected threat was to call 911, not to conduct an armed pursuit. They argued that by the time the fatal shot was fired, the opportunity to disengage had already come and gone. Looking at the facts that had been publicly discussed, I think there is a real strength to the argument. And this is where I think consistency matters. If we're going to tell Karmelo Anthony that he should have walked away, then I think it's fair to say Rick Chow should have walked away as well. Karmelo Anthony is guilty of murder. That's reasonable. He's guilty of murder. So is Rick Chow. Under the same exact circumstances. So is Rick Chow. And Rick Chow is clearly the person who pursued, clearly the person who created the atmosphere in which a person had a deadly outcome. Rick Chow is clearly the aggressor in this circumstance. Okay. So if we're going to tell one defendant that he has the responsibility not to escalate a confrontation, then I think it's reasonable to expect us to have said the same thing to Rick Chow. If we're going to say that deadly force is the last resort, then it has to actually be the last resort, not simply one option among many. For me, the common thread between these cases is not race, politics, or geography. The common thread is choice. In both cases, there was a moment where the confrontation could have ended. In both cases, there was an opportunity to avoid a fatal outcome. In both cases, someone decided to continue the encounter instead of ending the encounter. That is why, after looking at both of these trials, I arrived at the conclusion that the South Carolina jury was wrong in their decision with Mr. Chow. I think Karmelo Anthony was convicted because the jury believed he had alternatives to using deadly force. Yes, he did. I think the same reasonableness should have been applied to Rick Chow, based on the facts that had been present publicly. I believe the state made a compelling argument that Chow had alternatives as well, and that he chose not to take them. At the end of the day, justice is not supposed to be about whether we sympathize with the defendant more than the victim. It's not supposed to be about whether one story pulls harder at our emotions or our heartstrings than the other. It's supposed to be about applying the same legal principles to every case. The standards of eminence, necessity, proportionality, the restraint should not change depending on who is standing at the defense table. That is my final thought. This is where my final thought took me. Very simply, I can respect that reasonable people may disagree about these claims. I can understand why someone would believe both defendants should have been acquitted, or why someone would believe both defendants should be convicted. What I struggle with is the idea that the same legal system can tell one defendant that he had a duty to avoid escalating a conflict while telling another defendant that chasing and ultimately killing a fleeing teenager was legally justified. That's what I have a problem with. Okay? For me, if the law is going to mean anything, it has to be consistent. And when I apply the same legal standards to both cases, I come to the same conclusion. Karmelo Anthony was guilty because he had the opportunity to avoid using that deadly force. Rick Chow is also guilty because he had an opportunity to avoid using deadly force. But then Rick Chow created the circumstances that led to the homicide of Belton. Okay? Both were presented the same facts for both the cases. Self-defense. Rick Chow had an opportunity to avoid this fatal outcome, but he chose a different path. The same way with Karmelo Anthony. And both should have been found guilty. Now, the question as to why they were not both found guilty, when all of the facts presented would mean this is how it should have, the outcome should have come. I have no idea what was going on. I do know that the child case, that verdict is wrong, but we got to deal with what we have to deal with, and this is what the jury said. Both presented the same evidence, same statutes, everything applied the same, and yet we found one guilty and one not guilty. They both should have been found guilty. But that's my conclusion about the trial. It is what it is. Was not found guilty. 7 black folks were on it. Yeah, that's why Chow was not found guilty. 7 black folks were on the jury. I get all that too. It sucks. Guess maybe garbage steal you probably leave about it. Yeah. I guess you can walk into your garage and steal your property. That makes no sense. I don't know what you're talking about. Makes no sense. So if you like my commentary about this trial, the jury, anything, please hit the like, share, and subscribe. I appreciate it. I will be back tonight with some more content. And please hit the like, share, and subscribe. I appreciate all of you guys. I appreciate you guys showing up at 7:30 in the morning. I appreciate you, and I'll see you this evening at 10 o'clock. Thank you.